Today is Tuesday, December 7th, 1999, and it's my great pleasure to be here with Ashby Lohse, who is a 1939 graduate of the University of Arizona Law School. For the University of Arizona James E. Rogers College of Law, I'm Dean Toni Massaro. Thank you, Ashby.
You're welcome.
What we're doing is we want to focus on, I know you've done oral histories and more generally of your entire life. We're doing one of the law school in particular. So we just want to get a sense of what it was like and the changes that you've seen in it and those sorts of things, because we want to show it to, we're putting this together to show it to our third year students at the banquet at the end of this year, and hope to have it be something that future students will see, so they'll learn something about the history of their law school, just so you know what we're up to here. So how did you decide to go to law school?
Well, I've been in speech all my life. From the age of 4, I recited the Gettysburg Address before the Tucson High School, and that was just a start. So I had a father and a brother who were wholesale grocerymen. They loved selling. I did not. So I wanted to go into something I didn't have to sell. And I made a mistake and found out later on that all I do is sell ideas.
It ended up exactly right. Well, why Arizona?
I was born here. My folks came in 1904 and 5. I missed being born in the Arizona territory by 2 years. I had no choice. I know nothing but Arizona other than 4 years in the World War II.
And what were those like?
Those 4 years, frankly, is a wonderful vacation. I had just gotten started practicing. I went in as a second lieutenant. I'm sorry, my first lieutenant. I came out as a lieutenant colonel. Generally speaking, in the military, you have to have a chain of command. You go one step or below. I had nothing like that. My outfit was a tank destroyer outfit, Corps Reserve for the D-Day landings. They lost us in the marshalling areas. We got on board ship just as the storm hit. We landed when they were about 3 days behind in their schedule. But from there, we went in every single part of the 5 campaigns.
I'm glad you got home. So you were in law school before this point?
Yes.
Yes, you would have been.
Started in October, admitted to the bar, immediately made arrangements to share a office in the Valley National Bank's 8th floor with another attorney. I had no telephone listed in my name, no way to advertise. My first 4 months, I grossed $32.50. I got out of there. I shared an office with a chiropractor on Pennington. I had a office about double the size of this desk. I had a desk that I bought. It was about 18 inches wide just so I could sit behind it. Room for 1 chair. But I had a big window. Ashby Lohse, attorney at law. It started. It went from there.
When you went to law school, what was the admissions policy? Do you know?
As far as I know, there was no policy. I don't know, did not realize there was any terms or conditions, and I didn't think that the demand was greater than the faculty could handle.
How many students were in your class?
As I recall, about 23.
Were there any women in your class?
2.
Do you remember who they were?
I can remember one, Stella Rosenberg. I can't draw up in my mind the second one. Stella did practice in Tucson all her life.
Do you know what kind of law she did?
Mostly collections and divorces. It was a very low key and not very high pressure on her.
Mm-hmm.
She married another attorney, Mexican American, and they had their office down about Council Street. She was very well liked. No one could intimidate her. She did a very good job.
Of your classmates, were most of the students from Arizona, or were some out of state?
I think they were all from Arizona, to the best of my recollections.
What was the average age?
18 to about 22 or 3.
What did the, did everybody pass, or was there a high attrition rate at that time?
As far as I can recall, almost everybody passed. I can't think of anyone specifically who did not. I could be wrong at that point.
Did you go through the summer, or were summers off?
Summers were off.
Did they have internships at that time, or did you
No.
work for a law office in
No.
between?
Nothing.
Were there student activities or kinds of other life of the law school things going on?
It was a monastery. We were cut off from almost everything.
With 2 nuns?
From 4 years of activity, knowing everybody in the university, nothing.
That's interesting.
It's the only way we can learn and handle our pressure of our courses.
Where did you live? Where did the law students live?
Well, I lived at home, which was half a block away from my grade school, 1 block away from Tucson High, and 4 from the university. I could shoot jackrabbits between my house and the university.
What was tuition like at that time?
Almost non-existent.
What were the job prospects like when you got out? I hear you...
None.
Mm-hmm.
Tucson had 2 firms. One a big firm, let's say of about 6 attorneys, and the other one was a 2-man firm. I thought with my connections I could get in with that 2-man firm. It did not work out. So I started my practice all by myself.
What about your classmates? Did a lot of them just hang out their shingle?
I'd say most of them did. Paul Farron joined the feds. The one that I worked closest with, a man from Peter from Yuma, right now I can't think of his last name, went to Yuma, opened his own practice, later became county attorney there. I think he's now deceased. Jas Walters went to Phoenix, opened his own firm, even though there was a lot of other firms there. We had one man in our class, Laban Thorpe, who never practiced, never did a thing. He was a tennis player. Why he took the course, I don't know. He graduated, but never got into the field. Brinkley Pierce bought a tourist place just east of Texas Canyon and just this side of Wilcox. If you ever see the signs, look for the thing. He ran that. That was his place. He never practiced law.
What was the bar exam like?
Frankly, I can't think of a thing about that. It wasn't hard.
Was it essays, for the oral exam? 1 day, 2 days?
Chester Smith taught criminal law. And he gave us, this is first year, he gave us a play exam. In 4 years of college, I learned 2 things. One, I became a free trader, and how to outline. I outlined my answer. He gave me a satisfactory grade, which didn't count, but he says, never again. It's got to be essay. So to answer your question, everything was essay, so far as I can recall. I do not recall any multiple choices.
So,
Now, along that line, I had a partner for a short period of time who was one of the bar examiners. And he asked me to draw up the questions for the probate. I thought it was an interesting experience. I did it. He turned it in, and I got a short time later the report that they thought it was the most ridiculous thing that they had ever heard. It was so ungodly easy. After the exam was taken, it proved that it was the most difficult part of the whole exam. It raises a question that I had in mind about exams and teaching. I believe that some practical experience on these courses would greatly improve all matter of teaching. I wrote questions that were basically practice, and they weren't ready for it.
do you think that your education at the time prepared you for practice?
Yes, it did. But when you got out of school, basically you had no place to turn to. You didn't know what to do. You'd never been to a courthouse. You never filed a paper. The students that I had when I was teaching had never seen a complaint. I had the only practical experience that I received at school was in probate. Judge Smith assigned a specific document every time. We looked them up, at least I looked them up. I prepared it, it was never checked. I had no confidence in my work. So my first probate, I went to Salem Franklin Jr. and said, I'll split the fee with you if you will look over my work. And I did that. I did find out in my own mind that I probably could have done it by myself. Bell Hall, who was the clerk of the Superior Court, had a list on one page that she had made of key cases, their numbers, and the type of case. I got a copy of that. And whenever I had a case similar to one of those, looked it up, it gave me a pattern. One other thing about the bar at that time, it was small and every single one would help you. That isn't true today. And I've seen a lot of classes come out where they had no one. They'd call me up on the phone, how do you do this? Where do I turn?
You didn't have any clinical programs at
Not
that
at
time?
all.
Did you have moot court or trial advocacy?
We had a course in trial, and we all had a very small, 30 minutes, let's say, at most, trial. Mine happened to be a prosecutor on a break-in case, criminal. Beyond that, we had nothing. Moot court was just being considered in the 3rd year I was there. I never participated.
Now,
We had no law journal, nothing.
No law review.
No.
In your third year, was what precipitated that discussion of moot court? Was there a change in the administration?
Nope. No change in administration the entire time it's there. I just figured it's slow growth, evolutionary, nothing else.
Who was dean when you were in law school?
Feckley,
And for the entire time?
the entire time. I don't know how my father knew him, but before I entered university, my father and I went to his home and discussed with him what type of a basic education I should have before I entered law school. So I knew him before, I knew him all through the 3 years, and I've had little contact with him up to his death. But he was available to me if I needed it.
What was he like?
Very reserved, hard to know. A student of Wigmore, so his specialty was evidence.
Was he a good teacher?
I think they were all good teachers. They had different approaches. I don't know as anyone other than maybe Smith would meet the criteria that you probably have today. Smith was a small, bombastic man. He could jump around. And very frankly, with the small classes and those hard benches, we could stay awake.
How many, you said you had 22 or so in your class. Were you all together for every class period? So there'd be about 22 and
Basically, yes.
Who taught you property?
I'd say it's Thomas.
Floyd Thomas.
Floyd Thomas.
Yes.
And so you said in criminal law was
Chet
Smith, and evidence was the dean.
That's the dean.
And who taught you constitutional law?
Curtis, and I didn't take his case, of course.
Okay.
I've never had any.
And what am I missing? Torts.
Torts was also the dean.
You know these guys?
Agency.
See if you can, you may need your, especially the one on the right. We're trying to figure out who that fellow is.
I'm sorry, I can't. In the far right. I'm sorry, I can't see. I'm Feckley in the center, I can recognize. My eyesight is just too poor to help you on that particular.
Okay. Yeah, that's definitely Beckley. We think it's Leonard Curtis on the end, but we're not sure.
And say I had no contact with Curtis at all.
Mm-hmm.
I couldn't tell you other than constitutional what he taught, if anything.
How come you didn't take constitutional law?
Limited number of time that I could get my classes in. Not anticipating anything other than a minor practice type of thing.
How many years study was it? How long was law school?
3 years.
3 years. Do you remember much about graduation?
I'll never forget it. John Abile and John beat me by 2/100ths of a point being the lead. I slacked the last semester. But John and I think we were both Juris Doctors at a time when that meant something. You had to have a degree and make a certain grade. What is it Phi Beta Kappa?
Yes,
All around?
that's for undergrads, yes, the distinction, yes.
For each college?
Mm.
Is that right?
I think, I think you can only,
No, that's Phi
No, I
Beta,
think that's-
Phi Beta Kappa is just
arts and
yeah,
sciences,
it's Phi Kappa Phi. Is that the other one?
yeah.
We both made that.
Mm-hmm.
And we both are Juris Doctors. And we saw that for a doctor's degree, you go up there and they put your hood on. And we was a Juris Doctor's degree, so we were in line. And Chet Smith said, "Carry your hood up." And we approached Al Atkinson. I'm sure he got as mad as the house, but he had to put on our hoods. Alf was a Rotarian, so he is one of the presidents that I did know on a first name basis.
Why did it make him mad?
We should, according to all rules and regulations, we should have had our hoods on at the time.
I see. What was the predominant teaching technique? Besides this one guy who could jump around.
Calling upon a student to report on a given case, and then the discussion of it in class. It's basically the whole approach for all of them.
Did you have to stand and recite?
Yes.
We did too. Do you know if the faculty members had tenure?
No, I don't think they did.
Were your professors accessible?
Can't tell you. I never tried to get them.
Do you want to get that? Should I get
No,
that?
let it-
Okay.
the fourth one,
Alrighty. Well, how did they become law professors then? Do you know?
that I don't know. I have no idea how they came to university or anything else.
So you don't know what their backgrounds.
Not a bit.
Mhm. Who is your favorite professor? And why?
Well, I'd say Chet Smith is probably it. The ones we haven't mentioned is McCormick, who was the second one in line. He had contracts. That was an interesting course. But he was still kind of a quiet man.
So when McCormick came, he wasn't dean?
No, oh no. Faculty was the dean. McCormick, I don't know how soon after he became the attorney for the Board of Regents. There was a change in the administration as the president of the university, and they made McCormick president of the university. When they got a so-called permanent, technically trained, experienced president, Theckley was then retiring, and McCormick came back as dean then.
So he started as president and then came back as
He
dean.
started as a
Well,
teacher.
Right, I understand.
Yeah.
But his first administrative post was as president.
Yeah, that's right.
Wow.
Except as an advisor to the Board
Board
of
of
Regents.
Regents. Mm-hmm.
Yes. I can't recall how long he was president.
Yeah, I know. Yeah. It's this one you don't know who it is, right? Yes. I have it written down somewhere, but I don't know either. One of the things that we've looked at in looking at things that were written about Dean Feckley. They said that his emphasis was on the practical over the theoretical. Is that your impression of him? And do you recall any debate about the practical versus theoretical divide?
Well, in evidence itself, it has to be somewhat practical, because you're talking about specific techniques. But I would not have described him as being totally practical. Torts. You're talking about a specific action, more so than in contracts.
Yeah.
And so I think I've taken the position that's an area for difference of opinion.
Well, Dean McCormick, in what we've read, they say, and I know you weren't a student of his while he was dean, but you've been here and knew all the deans. They say that he stressed the relationship between the students and the lawyers and the judges. As a practitioner, did you notice some difference in the law school's relationship to the bar when McCormick was dean?
Yes. For the first time, he started bringing in some of the lawyers, such as myself, into teaching positions.
And what'd you teach?
I know I taught domestic relations. Dean McCormick would call me in whenever there was a shortage of some nature. If a professor got sick, I stepped in as an interim teacher. If he went on a sabbatical leave, I stepped in. I know Barnes did have some health problems. But right now, other than domestic relations, I can't recall what I did, but I was called in 3 times, other than my own course.
Did McCormick do this out of a philosophical desire to have a closer relationship between the students and the law school and the bar? Or did the class get bigger at that time? Or both?
Well, let me tell you about his call to me. He called me one day and said, "Ashby, I want you to teach a course in examining an abstract." I said, "Dean, we don't examine abstracts anymore. Everything is title insurance." I know, Ashby, but a lot of our students leave the state and go places where there is abstracts. I said, "All right, Dean, well, you can't examine an abstract unless you basically know the entire field of law. You've got to know domestic relations, you've got to know probate, you've got to know corporate law. Did they all handle the title to real property? If you will allow me to teach a general course on the things that you need to know when you get out into practice, I will put a title taint on it." And that's what we did. I had basically a lecture course, but to answer your question, I think he was thinking of the benefit of the students and nothing else. But I had a lecture course. I gave my textbook with a set of my forms, and I told them exactly what to do and when and how. I think the major portion of them had never taken for a future interest other than what I gave them on my, say, 15 minutes, A to B for life and then to C type of thing. I think he was more interested in the students, in getting an education in something that they might need.
Were there others with whom you practiced or knew who taught at the law school at that time? Were you the only one practitioner at that time?
No, I will not say that. For the 3 times I was called in, yes. Mm-hmm. But Bob Lesher, the son of the registrar, taught as a more semi-professional, but permanent instructor for a long time on creditors' rights.
When you taught, did you just come teach your class and go, or did you spend time with your colleagues and the students, or what kind of relationship did you have with the rest of the faculty and the students at that time?
None.
You just came, did it, and left?
That's right.
Mm-hmm. You give hard exams?
I don't think I did.
Sounds like you must have. From what the bar exam, what happened with the question on the bar exam?
No. Well, the only place that would come, I didn't teach probate per se. The only thing that I had in probate was the use of probate to clear title to real property and forms. Now, when I started out teaching, we were in the old-fashioned probate situation where every single thing was done under the control of the court. You go up there, you sit half an hour just to get a judge's signature. Then suddenly when Dorsey came along, the legislature changed that. I had some very close relationship with the Secretary of State, and I called her and said, I want a copy of that law. Ashby's coming out in October. I said, I'm going to be teaching it in June. So I got a copy of the probate law, the new one. I designed a set of forms for it, put it in my form book. And the forms that we use today are basically those same forms, almost no change. So I think I have to answer to your question. It was fairly easy. I did say to the class, it's a 1-unit course. I said, I think I can guarantee you nothing less than a 3. I flunked one good friend of mine. He did nothing. His answer on the test was totally, he got nothing right. No, I think I was an easy one. I had to grade on a curve. I've had no formal education for teaching. It's just my practical experience in athletics and everything under the sun. Peter, the young man, I still can't think of his last name. I tutored him for 3 years. We would get together every weekend and review everything that happened for that week. And then we started broadening it, covering 2 weeks, 3 weeks, 4 weeks. So I've had a lifetime of teaching of a style without being formally right or wrong.
Where was the law school when you went to school? We've been to different buildings.
Right by the flagpole. Do you know what I'm talking about now?
Yes.
Which one?
Mm-hmm, I do. What'd you do with those pictures?
As I recall,
This one?
I had all my 3 teaching courses there.
Uh-huh.
My office practice was done at the one at 5th and Park. I had the big room, got up to 90 students. It's big.
90.
It's a popular course.
Well, I believe
And the
that.
idea of getting something that might help them when they got out. Only a 1-unit course. No real study necessary for it. Was very attractive.
It's still attractive.
I would hope it would, but I haven't been able to talk anybody into doing something like that.
Well, there's a couple things that occur to me. One is the idea of a course not centered on property or this or that, but that's more integrated. Some years ago, there was a experimental project at Harvard where 5 of the first-year professors agreed that they would teach a problem, and then each of those people in their different subject matter areas would talk about the property law features of the problem, the procedure aspects of the problem, the tort aspects of the problem, and I think it's an extremely appealing idea because that's how these problems really come about. But it required such massive, either a very talented teacher like yourself who would be able to present it as a whole, or a very coordinated first year group of professors who could actually work out talking about the same problem as a whole.
That goes beyond whatever I would think about, but I've been pushing for more practical work in the basic courses taught by the professors.
Mm-hmm. One of it's a big issue. The McCrate report came out, how many years ago is that now? It was when Tom was still dean. And we talked about the desire that the bar has to have the law school teach more practical courses. But one of the things that was interesting to me when we were talking to Elias Romley about this, and you've reinforced it, is that when you were in school there was nothing. There was no clinic and or skills courses, and now we have quite substantial offerings. But you're really talking about something even more integrated, so that you wouldn't teach civil procedure, for example, without showing
expand Chester Smith's assignment of a form or probate. Why not have the contract man draw up a contract in this? And let somebody, with a teaching aid, go over it and tell the student, this is good, this is bad. It doesn't have to be much,
Mm-hmm.
but it's a start. And it would give us tremendous confidence that we might know something.
Yeah.
But you're right. Now, I'm satisfied that your practice court that you have is far superior to anything we've had. They at least get in, they get to see a judge once in a while.
They also, I mean, in clinic, they actually represent clients and prepare these
Yes,
things.
I
And,
understand that.
but I'm reinforcing there's a lot of support for your position, and the critique of law school as not being sufficiently practical has been out there a long time.
I do not know the extent to which you have clinics.
Mm-hmm.
I know about immigration. And to some extent, I'm not interested in it. It has a very limited interest to a general practitioner. Let's say it's far out from divorce, from marital situations, torts, contracts, any of those things, agencies.
Yeah.
So my approach basically is from the standpoint of the person who's going to get out and practice law.
Mm-hmm. Yeah, we have 4. We have the tribal law clinic and the immigration law clinic, domestic violence clinic, and the child advocacy clinic, and then some off-campus externships, prosecution clinic, and where they get more of what you're talking about. But I definitely understand your point, and I think that's the closest students come to the complete sense of handling a case and dealing with the client and preparing documents and carrying it through. And it probably is more parallel to what you're talking about if you're working in the child advocacy clinic or a domestic violence clinic than the tribal clinic or immigration. We also have pre-trial litigation courses and trial advocacy. It shows them what the documents are and practice preparing it.
You're getting towards that.
Yeah.
With that.
Mm-hmm.
I accept that.
Yeah, there's also some other models that you probably would like better. An example, William and Mary, their first year, they have, as the small section experience, law office practice. And at Florida, where I taught before, they have a legal drafting program in addition to legal writing. where the students get the exposure to drafting various documents, just what you're talking about. Again, though, that ends up being separate from the substantive course, and that's still not integrated as much as you might like.
I don't think it has to go to extreme on that thing.
Mm-hmm.
If they do enough to get a start and get confidence, if they're told where they can go to get a form for it,
Yeah.
things of that nature. When I got out, I knew nothing. Now, living here all my life, I knew where the courthouse was. I've been there. But a lot of students didn't even know that.
Yes. I know.
All right.
I understand. The type procedure, till I moved here, would have them do a complaint, an answer, a motion to dismiss, and so on. But it's just here, it's the small section with legal writing where you had to teach them to write a memorandum and other things. But I think a procedure course really is enhanced by having them do that. They did a deposition and we videotaped it, and it was small. It wasn't the complete thing, but at least so they get their hands on the documents for that very reason, so you're not freaked out at your first job.
Well, I was very fortunate. I was in school at the time the new federal rules came in on pleading. So the only
That's
thing
right,
I
you
learned
were.
was that, and not demurs and all those other things.
Right, right.
Even after I got out of school, when the Pima County Bar was putting on talks, I attended. But those old poor other attorneys, they couldn't conceive of a lifetime with demurs and the keeping things secret. And now full disclosure. The
Boy.
practice was ruined.
Well, I hadn't thought about that. You would have been in school at that time, because teaching procedure, that is the most important year. It was 1938 was a phenomenal change
Yeah,
in
right.
attitudes with respect to pleading.
And the whole attitude about courts.
Sure, absolutely.
My father was very involved as jury duty in the early days. He knew everything about secrecy. You don't tell them this, you don't tell anybody anything. You just surprise them at the trial. Surprise all goes out.
Mm-hmm. Mm-hmm. And
To
one form of action instead of
Yeah.
all the different forms, and the merger of law and equity, all that in 1938.
That's right, well, I was there.
That's really cool.
Yes, it was.
And Erie versus Tompkins was decided then. It was just that was an amazing year in procedure. You were there.
I was there, no question about that.
As a procedure teacher, this is very exciting. Hadn't really thought that through. All right, sorry, that's my little digression.
It's okay.
Okay, well, what would you say? I'm wondering about this, and it's a matter of impression. Is the defining characteristic, if there's something about the U of A College of Law that you think stands out and defines it, or some things, it doesn't have to be just one, what would that be? That make it special or different?
During the time I was there,
Mm-hmm.
small classes. We all had to participate. I know that the size of the school has tremendously increased. I have no answer to it. When you have 100 people there at one time. I had a suggestion, one idea. Suppose if you have a 3-day-a-week course, you had days of the same, what you're doing now. But a third day, when you break them out in small groups, 8, 10 at once, and let them discuss what happened to those days, what their present educational system is. I regret very greatly the loss of friendship in the bar. When I started out, every single lawyer would drop anything to answer my questions and help me out. You couldn't get that under any circumstances today. there is no friendly relationships. Well, Phoenix was the worst. Tucson was much better for a long time, but it's getting to the same stage.
What explains that in your opinion?
Well, that one decision where Sandra Day was the sole dissenter, in my estimation, totally destroyed law as a profession. It's now only a trade. Everybody advertised. My partner and I were old dinosaurs in Argo. We never advertised. Our name's in the telephone directory, and that's the only place you'll find it. Nowadays, TV and everything else, certified this, certified that. I can't see any distinction between that and somebody selling cars.
You think it's mostly advertisement or other things too?
It's other things too.
You think we can stop it?
I don't know it's going to be hard, but I'd certainly like to see a lot of talk in the school about professional honesty. When you give your word to an attorney, you keep it. Things of that nature. I had one extreme case of my own. On a small case, mostly some amount of money. We settled it between our two attorneys, and our clients approved it. By the time it came to finalize it, my client changed his mind. I had a simple solution. I wrote the attorney on the other side, told him what happened. I said, figure out the damages, send me a bill, and I'll pay it personally. I showed it to my client. After I mailed it, he changed his mind and went through with it. But unless you stand for something, I don't know that the people today have that. Now, I've been out of practice for about 4 years now. But up to that point, I had seen very little progress.
If you wanted to convey a message to future law students, what would it be?
Well, let's say most of us old-timers have come to the conclusion that we would probably not pick law as a profession. It's not the same. The joy of it is going out. It's money and money alone. I sound like a radical, and to some extent I am. I don't know. I enjoyed about 58 years of practice. But I don't know, I don't think I'd want to have to practice today under the present situation.
Well, we're going to have a talk at the school later this week by a social economist who's looked at intangible and tangible factors in job satisfaction in the practice of law. And it's interesting. I don't think it's surprising particularly, but it's interesting that there are still parts of the profession where people report more job satisfaction than others, and it's not monetary. It's the intangible things that offset the financial benefits. Some public interest, public sector work may be more rewarding in a whole human sense, and I think it's an interesting study that I would think would be interesting to students.
I had a very enjoyable practice for some time on adoptions. is one of the nicest things I ever did. I've seen a baby given to a new adopted mother, and within 15 or 20 minutes, she can see all the family resemblances. I got out of it when the legislature started putting all the terms and conditions and insisting everything be done under the state. There's too much legislative, governmental authorities. Someday I want to sit down and talk to you. Is there anything left of state rights? We're in a changed situation. And as old people, don't like it.
Well, that's state legislation that you're talking about for adoption, so that's states' rights. It's individual rights you're interested in.
But I'm just saying, in the federal field, I think they've wiped out so much of state rights.
There is no question that since the New Deal,
It's a New Deal, that's right.
the rise in federal legislation has been, unprecedented. That's a
But
fact.
it's also being followed by the state legislatures.
Mm-hmm.
There are people who want, there's a law for everything.
There are two laws for everything.
No,
Yeah, that's
I apologize to say,
federal and state.
to some extent, I'm the wrong person for you to ask some of these questions.
No, you're the perfect person. This is what we want to hear. What you think. I mean, these are things we're going to weave into a story that we want the students to have a sense of. The people, they are, the continuing story, and that they don't understand. You have to tell them in constitutional law how this has changed, because some aspects of the federalization of things they grew up with, and so they have no sense of another way in which that might not have been the case. And then we talk about, well, how did that come into place, and how do you unravel it? One thing about government at any level is once they go to one level of regulation, it's hard to go back in the other direction. We had an economist from the University of Arizona come talk about some legislation that was put into place to protect wheat growers during the Depression that's still in place, and talking about the only reason it's still in place is it develops an incentive for wheat growers to grow a certain level and receive certain benefits, and the reason for the rule has long since expired, but the rule persists and serves certain groups because they've figured their way around it. I think that's probably a function of rules, almost no matter where you put them into place, unless they're monitored and they're sunsets. What were we going to say?
Well, I don't know as I agree with you. It's going to be almost impossible to change in many areas. But take this gun control. Register. What does registration do to prevent kids doing things? To pick out something that they can't prove does anything to protect makes no sense to me. This last kid we had in school in National had a wonderful school record. No problems of any nature.
The Oklahoma Matter, the
Yeah.
one in the news today. Mm-hmm.
Mm-hmm.
Mm-hmm. I don't know, and that's a problem that I have no idea.
Why do we have so many divorces?
People don't like each other. Sorry.
Well, I don't think that our marriage ceremony is worth a darn. Love, honor, and obey. I've come to the conclusion that unless the woman is willing to say, here I am, I give you all my rights. Take care of me. And the man says the same thing back to her. Has that eliminated the word I my rights? If you have all of my rights, what can I claim? If I have all of your rights, don't we have to cooperate and compromise to work something out? I'm just saying to you, I don't think we have commitments in marriages anymore.
Marianne Glendon has written a book about the legalization of American culture and pointing to the believes that there's a problem that's created by the right versus responsibility part of the rhetoric, and that people understand their relationship to others in terms of their rights rather than thinking about it in terms of their responsibilities.
That's putting it in a different way.
Mm-hmm. And there's also a very active both in the scholarship and more generally communitarian movement, arguing that people need to, want to, and will have no real hope unless they think of themselves as part of a community. And that also is thinking of oneself differently, I think, and less about your rights than about what you give to others as part of the relationship.
If I was teaching domestic relations again, I can see a lot of social comments on my part. Trying to force them to say, are you willing to commit yourself in a marriage? I think progress can be made, but the possibility of it doing is very slight.
Well, on the marriage one, you have stated it differently than some might, and in a way I actually very much agree with. You're not saying she says. I mean, I give it up, and the historical construction of this, and he says thank you, and I'll take it, and there's not that exchange.
But it has to be on both sides.
Mm-hmm. It may be
and
that
I don't see how the wife gives up anything by doing that.
Mm-hmm.
Because the husband does not have the ability to dictate, because he's given that right to somebody else.
Mm-hmm. What do you think of these new covenant marriages, where state will give you an option of two kinds of ceremonies? One of them involves more of a promise and trying to keep people together. And if you've opted for the covenant marriage, it's harder to get out of it than if you opt for the other kind of marriage.
Well, I don't see that, as a general rule, that's going to get very far. Look at the Catholic Church. No marriages. No divorce, I should say. And yet there are some who still will say, I don't care. We're going to have a divorce. One of my names up in the board, the foundations I have, Catholic, got a divorce. Basically, he was out of the church. He maintained a very close relationship with some of the padres. But there was no penalty so great that would keep him away from a divorce. And I see the same thing for this covenant. I don't see that as a real solution. I think it's a step in the right direction. It is beginning to make them realize that they have something is that may be a burden upon them. They just can't walk out. But one of the worst things that's happened is the entertainment field, where they change wives every week, or they live with somebody without benefit in marriage or anything else. We've liberated women, I think, to some extent, in their detriment.
So do some.
And men are taking advantage of it.
There's a pretty, again, you're really have your finger on the pulse of a lot of the debates. I mean, that is within the feminist literature. There's all different. It's not one point of view, and one of the points of view is when some of these efforts to equalize have actually ended up compromising or burdening women in ways that are not always anticipated.
One of the worst things is no fault divorce. No protection at all. That hurt women.
They also argue that where they neutralize looking at custody decisions, they make it gender neutral. It ends up having a disparate impact or can on women, where if they look at something objective like economic factors, and then again and again and again, she's less likely to have the economic wherewithal. There's lots of examples of it, perverse, unexpected consequences.
Feel I shouldn't be talking about. When I started out practicing law, we had one judge, one setup. He took care of everything. Now we have divisions of the court, a domestic relationship court, their own rules and regulations, totally independent of anything else. You've got to have a degree almost to handle a divorce nowadays. But it's a continuation of government setting everything. They have, so the individual judges do not have to decide each case separately. They have rules about property divisions, percentages, and everything.